This is State of Ohio v. Ross. We have Rick Raley representing the State of Ohio and Giovanna Bremke representing Mr. Ross. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, Ms. Bremke, for rebuttal, please let me know, as I will be keeping track of time. Why don't we just get that out of the way? Would you like to reserve time?
I would. I'm going to try to reserve 5 minutes.
Okay, 5 minutes it is. Please keep your voices up because these arguments are being recorded and I believe streamed live. You should not use the names of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. The judges have read your briefs and are ready to proceed when you are.
Thank you, Judges Giovanna Bremke on behalf of Mr. Ross. I'm going to exclusively focus on my first assignment of error, understanding that I have several assignments of error and also the state has a cross appeal, but the first assignment, and I think they're all equally as important, but the first assignment of error has a lot to unpack. It's also a matter of first impression. I think that's the one thing that the trial court, Mr. Ross and the state agree on, is that there's no law that any of us could find that controls this situation. What happened here is that a witness, I'll refer to her as BN, was invoking her Fifth Amendment right, and was declared unavailable. The court agreed that she had a Fifth Amendment right not to testify. That was on transcript page 96. And I say this is a matter of first impression, and it is, but the staff notes to evidence rule 804, which is the forfeiture by wrongdoing evidence rule, gives us some guidance. And I bolded that at the top of my assignment of error in my brief. But essentially that staff note provides us guidance that, number one, encouraging a witness to invoke a valid privilege, whether it be Fifth Amendment, spousal privilege, anything of that nature, does not trigger wrongdoing. That's important because that's what the state is alleging happened here, that Mr. Ross encouraged the witness to invoke her Fifth Amendment right. Second, it tells us that the state cannot make a witness unavailable and by failing to immunize them. So again, that's what happened here. That seems like an obvious thing because what we know generally about the law is that a party cannot invite the error and then use it to their advantage. So the state here alleges that Mr. Ross, my client, made Ms. Nolan unavailable by threatening her through calls and letters. They sought to introduce those calls and letters, and they were introduced without Mr. Ross's opportunity to cross-examine those statements. So ultimately, this court in this issue is going to have to decide who caused the unavailability. That's what it comes down to. The state alleges that Mr. Ross did. We allege that the state did. And another part of the transcript, and when you're looking at this forfeiture by wrongdoing part of the transcript, it's at the very beginning. It's about transcript page 40 through 100. But on the 76 page, there is talk from Ms. Nolan, who appears in court with her counsel. So she doesn't fail to appear. And that's important because the state cites two cases, Artis and Harper, in support of their position. And in those cases, the witness was validly served with a subpoena, but refused to show and testify. So that's different here because she appeared in court with counsel. And what counsel said on transcript page 76 is that she was unavailable, or that she was available to testify, and that she would testify. She would testify honestly and truthfully, but she needed to invoke her Fifth Amendment right because the state was threatening charges. And if she was immunized, if she was granted immunity, then she would testify truthfully and honestly. But the state failed to immunize her. her attorney actually indicated that they provided the state with notice 6 months in advance in September of 2019 that she would invoke her Fifth Amendment right and that they were requesting immunity. The state, this wasn't something that happened on the morning of. And to put this into context of why Mr. Ross is alleging that that the state made the witness unavailable, and why the court found that she had a valid Fifth Amendment right, is because the state, there was 2 cases going on. So Mr. Ross and this witness who share a child together were involved in a case that happened subsequently to these murders, but happened subsequently, was charged before the murder charges. And in that case, that's when these letters were written. So these letters were not written in the context of this murder case. And that's important too, because Mr. Ross was not able to cross-examine to bring out the context of those letters. And in the throughout the course of this drug investigation, these drug charges, the state was actually surveilling this witness, was following her around, but waited until she was 37 weeks pregnant to arrest her, take her to jail, and waited to give her, to do her proffer until she was in active labor. She was having contractions. She lost her mucus plug while in the prosecutor's office during her proffer interview. And during that time, they're saying, I'm going to call Children's Services. I'm going to call Section 8. You're going to lose your housing. You're going to lose your child unless you tell me what, you want to hear. And the reason that we know that she felt this way is because she said in one of the calls that was introduced by the state that she said I did what I had to do to get out of jail. And that's because, again, she's in active labor having her baby. They told her they would give her 1 day for a medical furlough to have the baby. They would remove the baby from her care and return her to jail until she, provided them the evidence that they needed. And this whole time they're threatening her not only with charges, but with, Section 8 and Children's Services repercussions. The state also cites one other case, and that's State v. Dunlow. And they rely on that case. And in that case, it's important to note that the court did not find that there was a valid Fifth Amendment right. So this is a case, again, matter of first impression, where there is a valid Fifth Amendment right. Nobody's contesting that. The state did at trial, but the trial court found that there was a valid Fifth Amendment right. And she invokes this valid Fifth Amendment right. The state fails to immunize her and then uses that to introduce statements that Mr. Ross could not cross-examine. In addition to that, and to compound the error, Mr. Ross's counsel asks to put the witness, I won't use her name, put her on the stand, and so that the counsel for Mr. Ross could examine her on whether she on why she was invoking the Fifth Amendment right, and the court did not allow this. So that compounds the error because it could have, she would have been able to testify as to that. We also know that it was the state that caused her unavailability and not Mr. Ross, because she says in her grand jury testimony that she's not afraid of Mr. Ross, and this is all cited in the transcripts, and it was in the defense motion. But during the grand jury transcripts, she says, I'm not afraid of Mr. Ross, and who is he in a position to threaten me? Another issue is the state has brought up in their brief that this is harmless error. It's not harmless error. If you look at the facts in this case, there's no murder weapon, no video, no photos, no blood, no footprints, no DNA, no eyewitness. And without the statements that were admitted that Mr. Ross, again, could not cross-examine, there would not be that evidence to sustain a conviction. So certainly it was, not harmless. And in addition, again, I've said that the court compounded that error by not allowing Mr. Ross's counsel to examine Ms. Nolan outside of the presence of the jury on the reasons that she's invoking the Fifth Amendment right, although she did speak through her counsel. I would reserve.
Counsel, what specific evidence would you allege that BN testified to makes this not harmless error?
I'm sorry, what was that?
What specific testimony that BN gave the witness in this case make this not harmless error? In other words, did she testify, yes, I know he is the shooter? What did she say that was so strong that the jury would have not ruled differently but for her testimony?
Yeah, there was, again, they were over the course of letters and calls, and there was statements made that would, implicate my client. And this question sort of puts me in a difficult situation because I'm also alleging later in the brief that there, wasn't enough evidence there. And I don't think there was, but again, the most incriminating part is these letters that would implicate Mr. Ross. So there's many statements, there's many letters, and that evidence is the only evidence that would remotely place him in context of this case.
Attorney Bremke, I just want to let you know you are moving into your rebuttal time.
Yes, I would reserve the rest of my time. Thank you.
Thank you. Mr. Raley, when you are ready.
Thank you, Judge Sutton. Good morning, Judge Sutton, good Judge Hensel and Judge Stevenson. May it please the court, just for the record, I am Rick Raley. I'm appearing on behalf of Lorain County Prosecutor J.D. Tomlinson and the state of Ohio. I am asking that this court affirm the defendant's convictions, however, that it reverse his sentence insofar as the trial court failed to properly impose firearm specification prison terms. Based on Ms. Bremke's presentation, I'll also focus on the first assignment of error. Before I get into that, though, I do think a general overview of the evidence at trial that convicted Mr. Ross is important for this court to consider. In most murder cases, the state is in a very good position when it can offer evidence that proves the means of the crime, the motive for the crime, and the opportunity for the crime. There was plenty of evidence offered on all three of those points at this trial. Most notably, one of the victims was a drug dealer who was known to be an informant that ended up incarcerated another drug trafficker. The defendant was related to that drug trafficker who was incarcerated. We offered evidence that there was a firearm in the defendant's hand weeks before this murder, and we showed evidence from cell phone records that placed the defendant's cell phone as well as a burner cell phone that he had been calling that day that were both at the location of the murder at the time of the murder. Also, there was plenty of evidence offered about after the fact consciousness of guilt from terms of the defendant fleeing to North Olmsted. The defendant was tied to the black Ford Escape that was seen driving away from the murder scene. He went to that owner of that vehicle and said, hey, you need to report this stolen. And once he learned that the police had found out about that car and it had been repossessed, he became very nervous. All the evidence I just went over, judges, has nothing to do with BN's testimony. All of that comes in through independent other areas from the cell phone records, the black Ford Escape owner's testimony himself, as well as other testimony about the connection of the defendant and the victim and his role as an informant. And at the first day of trial was when we litigated this issue of forfeiture of wrongdoing, and the state offered extensive evidence about the pattern of manipulation from really years of the defendant calling the victim, BN, and telling her multiple times, I need you on my side. I need you to go ahead and back up my alibi. He's told her to duck service. He told her, she either needs to not testify or she needs to testify in a way that's beneficial to him. And she claims that only she can be the one that really exonerates him. Now, in response a little bit to Ms. Bremke's points, there is an indication in the letters that there's another case going on involving these two individuals. However, it's clear from his calls, his language of he talks about this death case because it was a death penalty case originally indicted. So it's clear that they're referring to this death penalty case. He goes ahead and he says, if she goes to the police, I'm going to F word with her head. There's those kinds of comments are interspersed throughout these calls and these letters. And that pattern of manipulation led to what he wanted. She would not testify about this incident. And this is very common. What we see in domestic violence cases in particular. I cited to this court's decision in Finkley just from last year. Pressure, manipulation, and that leading to a victim, I'm sorry, not a victim, a witness being unable to testify is forfeiture or wrongdoing is clearly contemplated by the rule. And I disagree with the assertion that this is a matter of first impression. I do think that Donlow case from the 7th District, there is a Fifth Amendment assertion in that case. The witness refused to testify. Whether the privilege was valid or not, that did not matter. Still, the court said that the witness's testimony in that case was admissible under the forfeiture by wrongdoing provision. But really, ultimately, I think a lot of this is an academic discussion because BN's testimony is completely duplicative of everything else that's being offered at this trial. And I think it's pretty fitting that, you know, when she was asked, Ms. Brumke really couldn't explain which one of aspect of her testimony, of her statement, was so significant for the state. Really, there were 3 big points from her statements that were offered as testimony at trial. Number 1, the defendant lied about his alibi. We know about that from his cell records. Her testimony was completely duplicative. 2, he fled to North Olmsted. Again, his cell phone records show that he fled to North Olmsted. And the third one was that the defendant was concerned about the Ford Escape being repossessed. We knew about that from the owner's testimony himself. So everything we get from her statements come in other ways. And if this was to have been improperly admitted, it really had nothing to do with the conviction. And, you know, this issue about cross-examination and the ability to impeach her statements, you know, there was already put in the record that she made multiple statements about this incident. So there were ways for the defense lawyer to go ahead and impeach her without her actually being present. So without, if there are any further questions, I would just, you know, rest on my argument this morning.
Are there evidence in both the letters and the phone calls that would show Mr. Ross's threats, in your opinion?
I really wouldn't describe a lot of them as threats. It was manipulation. It was pressure. They would come from both the letters and the jail calls that were submitted to the court. And the trial judge received all of those and made a decision that there was wrongdoing in this case. But yes, I believe that all of it would apply.
I recall at least that BN testified that Mr. Ross threw his jeans away on the trip to North Olmsted. That's some evidence, at least, that you don't get from any other source. Is that correct?
Theoretically, I could not find necessarily where we would get that somewhere else that could endanger the tampering charge. But in terms of the murder charges, nothing that she provides is, you know, anything that isn't provided elsewhere on the record.
Judge Hensel, any questions? Or Judge Stevenson?
Thank you, Your Honors.
Thank you. Ms. Brumke, you have 4 minutes and 45 seconds for your rebuttal.
Thank you, Judge Sutton. I did want to circle back to Judge Stevenson's question about the evidence or that was provided in these statements. And I also previously failed to mention that not only were the letters in the jail calls introduced, but also her proffer, which is significant because of what we know about that proffer and the pressure that was put on BN to make that proffer. But there are items in those letters, particularly about Mr. Ross's alibi, that, you know, there are things to indicate that maybe he wasn't where, you know, where he had previously said he had been. and also that he had access to the black SUV. There's discussions about a metal detector and going to find, some sort of potential evidence. And the reason that the state knows these are important and that they've previously said that they're important is because transcript page 1292, they say these statements from BN are what basically led to the arrest of Mr. Ross. And the state has said, oh, well, he was a drug dealer, so that's enough evidence basically to implicate him in this murder. That's absurd. That would mean any drug dealer is a potential suspect in any murder case. That he fled to North Olmsted, which is 20 minutes away. That's not, something, again, that's wouldn't implicate him in this. That's not even enough to charge in this case on the murders. The state understands how little of evidence there is here. And the reason that they know that is because they started the trial with saying Mr. Ross was the shooter. In fact, there's a bunch of, and I go through this in my brief, that he's the shooter, he's the shooter, he's the shooter. And in closings, they say, actually, he wasn't the shooter, but maybe he was there. So they know that the evidence in the testimony that came forward is not the strongest for them. And and that was already, after the testimony and after BN's statements that were admitted. Without those statements, it certainly wouldn't have been enough to sustain a conviction. Also, I want to again point out the Dunlow case because the state alleges, well, it doesn't matter whether there was privilege or not. And in Dunlow, there wasn't a valid privilege, but it doesn't really matter. I would submit to you it does, because again, at what moment in time did BN become unavailable? She was there, willing to testify and able to testify. It was when she invoked that Fifth Amendment right is when she became unavailable. That's very inconsistent with the cases that the state has cited, because in those cases, they either didn't appear or didn't have a valid privilege. It was at the moment that she invoked that Fifth Amendment right, and the judge found, transcript page 96, that she had a valid Fifth Amendment right not to testify. And the reason for that is because the state made her unavailable. The state failed to immunize her, and the state threatened charges throughout her entire proffer. So again, this is going to come down to who made BN unavailable. And it's clear that it was the state. At that moment in time that she invokes that Fifth Amendment right, it's the state that makes her unavailable. This is not harmless error. There again, another reason we know it's not harmless error is because the state says, if basically, regardless, I'm going to ask that it come in by forfeiture by wrongdoing. That's transcript on page 40. If you don't allow it in, I'm going to ask for forfeiture by wrongdoing. If regardless of what she was, regardless of how they wanted it forfeiture by wrongdoing. And the significance of that is there's no ability to cross-examine. And there's a huge amount of testimony or a huge amount of argument about the inconsistencies of BN, that she had made several statements that are very inconsistent, and both parties, the state and the defense, say, I don't know what she's going to say when she gets up there and testifies. But what the state knew is that without the ability to cross-examine her, they would have their one story and their one version of her story, and that's why they wanted to get it under forfeiture by wrongdoing, and that's the reason they failed to immunize her.
Ms. Bremke, you're going to need to wrap up because your time is up. Okay. Again, I would ask that you reverse Mr. Ross's convictions on the issue of forfeiture by wrongdoing, or on many of the other assignments of error that I have laid forth, but I think they speak for themselves in the brief. Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and it will be also posted on the Ohio Supreme Court website. Thank you.